Good morning, everyone. Please be seated. We have quite an extraordinary case before us today, and I want everyone in this room to pay close attention to what unfolds here. Let me tell you something. I have sat on this bench for 43 years. 43 years. In that time, I have seen just about everything a human being is capable of. I have seen heartbreak. I have seen redemption. I have watched people at their absolute worst, and I've watched those same people claw their way back and become something remarkable. But every once in a while, a case walks through these doors that reminds me exactly why, after 4 decades, I still show up every single morning, why I still put on this robe, why I still sit in this chair. Today is one of those days. 43 years ago, when I was first sworn in, I was handed a set of robes that had belonged to the judge before me, and I remember thinking that I could never fill them. 4 decades later, I understand that the robe is never really about the person wearing it. It is about what it represents, a promise to the people of this city that when they walk into a room like this one, they will be treated fairly, regardless of what is written on their bank statement. Before we begin, I want to make one thing absolutely and unmistakably clear. This courtroom is a place of respect. It is a place where we seek justice, yes, but we do it with dignity, with compassion, and with fairness. I do not care if you are rich. I do not care if you are poor. I do not care what your last name is, who your father is, what your father built, or how many buildings carry his name on their facade. In this courtroom, every single person who walks through those doors stands equal under the law. That is how it works. That is how it should work. And that is how it will work for as long as I occupy this chair. So let us talk about why we are here. The defendant standing before me is a young man, 23 years old. His name is Maxwell Robert Thornton, born March 12, 2001, currently residing at 1847 Blackstone Boulevard on the east side of Providence, Rhode Island. He is the son of Robert Thornton, CEO of Thornton Industries, one of the largest real estate development companies in the entire state of Rhode Island, with a company valuation north of $400 million. I want to be clear about something from the outset. What matters far more than his name, far more than his father's title, far more than Thornton Industries and its $400 million valuation is what this young man did. And I am going to walk you through it in careful, deliberate detail, because this is not merely about a traffic citation. This is about something deeper, something more troubling, something that cuts to the heart of whether justice in this city means anything at all, or whether it is simply a word we invoke when convenient. 3 months ago, on August 15th, 2024, at approximately 4:30 inches the afternoon, on an ordinary Thursday, this young man was behind the wheel of his vehicle, a 2024 Range Rover Sport, white Rhode Island license plate, TH4582, worth well over $120,000. And he drove it recklessly, dangerously, with a stunning disregard for human life, straight through the Elmwood neighborhood right here in Providence. When I say recklessly, I want you to understand precisely what I mean. We are not talking about 10 miles over the limit. We are not talking about a momentary lapse in judgment. We are talking about 70 miles per hour in a 25 mile per hour zone, 70 miles per hour on Cranston Street between Haskins Avenue and Broad Street, a residential street, a neighborhood where children play in the afternoon sun, where families walk their dogs, where elderly couples cross the road to visit their neighbors, where people live their lives and reasonably expect to be safe in front of their own homes. Elmwood is not a wealthy neighborhood. It is a working neighborhood. Nurses, bus drivers, school teachers, small business owners, people who get up early and come home tired and just want their street to be quiet and safe for a few hours in the evening. I mention this because I think it matters. I think it matters that the streets this young man treated like his personal racetrack are streets where people do not have the luxury of a private security detail or a gated driveway. They just have each other, and they have the basic expectation that the law will protect them the same way it protects anyone else in this city. But it gets worse, far worse. Stay with me, because every detail that follows matters enormously. When he was pulled over by Officer Daniel Martinez, badge number 347, an 18-year veteran of the Providence Police Department, at the intersection of Cranston Street and Haskins Avenue, he showed no remorse, no concern for the people he had just endangered. He did not pause, look at this uniformed officer and say, "I'm sorry." He showed none of the basic human decency we expect from one person toward another. According to the police report in front of me, case number PR 202484582A, when Officer Martinez approached the vehicle at 4:37 p.m. and calmly asked if he understood why he'd been stopped. His exact words, and I am reading directly from the official report, were, "Do you know who my father is? He owns half this city. I can have your badge by tomorrow morning." I will be honest with you. When I first read those words, I set these papers down on the bench and took a long, quiet moment. Because that sentence, arrogant, dismissive, contemptuous, tells me everything I need to know about what we are actually dealing with here. This is not about speeding. This is about someone who believes without a shred of doubt that money, a powerful surname, and a father with deep pockets place him above the law, above consequence, above other human beings. That belief is why we are all here this morning. The story does not end there, and the parts still to come are in many ways the most revealing. Officer Martinez, the consummate professional, stayed calm. He did not react to the provocation. He explained in measured professional terms the seriousness of the violation, nearly 3 times the posted limit. Real lives endangered in a real neighborhood. And do you know what happened next? The defendant laughed in his face. He pulled out his phone and began filming the officer, announcing he was about to make him famous for all the wrong reasons. He stood in front of a law enforcement officer who had every right to escalate the encounter, and instead he mocked him. Officer Martinez could have let that get under his skin. He would have been entirely human to do so. He did not. He issued 3 citations at 4:49 p.m., numbers 24 to 8,847, 24 to 8,848, and 24 8,849D for reckless driving, excessive speeding, and creating a public hazard. He documented everything properly. That is what good police work looks like. That is what integrity under provocation looks like. Here is where the case takes a darker turn. After receiving those citations and returning home, the defendant did not sit quietly and reflect. He did not call a family member and express regret. He opened his Instagram account username, Max Thornton, official, a public account with over 47,000 followers, and started posting. He mocked Officer Martinez in front of nearly 50,000 people. He called him a rent-a-cop and a power-tripping nobody. He used a platform with real reach to publicly humiliate a public servant who had done nothing more than his job. Those posts went up on August 15th at 6:22 p.m. and again the following morning, August 16th at 10:15 a.m. They have been entered into evidence as exhibits C through G. One video alone drew over 12,000 views within 24 hours. 12,000 people watched a police officer be ridiculed for having the audacity to pull someone over for driving 70 miles per hour through a neighborhood full of children. And then this is the part that stays with me. This is what keeps me up at night. 3 days later, on August 18th, 2024, at 2:15 inches the afternoon, he was caught on a Ring doorbell camera belonging to Mr. and Mrs. Richard Coleman, 247 Haskins Avenue, in that same Elmwood neighborhood, doing the exact same thing. Same white Range Rover, same license plate TH4582, same reckless speed, same total disregard for the people living on that street, as if the citation never happened. As if Officer Martinez never stood there and explained the danger. As if the law, this institution, this system built to protect everyone meant nothing to him whatsoever. I want you to sit with what it means when someone repeats that behavior 3 days after being cited. A mistake happens once, and a person regrets it, learns from it. What happened on August 18th was a deliberate choice, a message, a statement in the clearest possible terms that none of this was believed to apply to him. Before we move further, I think it's important that the record reflect the human side of this, not just the paperwork. This court heard directly from a witness 2 weeks ago, and I want to revisit that testimony now, because numbers and citations only tell part of the story. Dorothy Henderson, 72 years old, took this stand under oath on September 9th. She sat right there in that chair, hands folded in her lap, and she told this court what it felt like to be walking home from the pharmacy with her husband Frank on the afternoon of August 15th, when she heard what she described as a sound like a jet engine coming up Cranston Street. She said she didn't have time to think. She said her body moved before her mind caught up, and she grabbed Frank's arm and pulled him back onto the curb so hard that he bruised his hip on the mailbox post behind them. She said, and I am quoting from the certified transcript, that in that half second she thought, this is how it happens. This is how people die on their own street. She said she has not walked that stretch of Cranston Street since without feeling her chest tighten. Frank Henderson, 74, corroborated every word of it. He told this court that he taught social studies at Hope High School for 31 years, that he has walked that same route to the pharmacy for over 2 decades, and that in all that time, nothing had ever made him afraid of his own neighborhood until that Thursday afternoon. I bring this up not to pile on. I bring it up because it is very easy in a courtroom surrounded by legal terminology and citation numbers and exhibit letters to lose sight of the fact that reckless driving is not an abstraction. It has a face. It has 2 faces, actually, Dorothy's and Frank's. And I watched both of those faces as they testified, and I will not forget them. I also want to note for the record that when Mrs. Henderson finished her testimony and stepped down from the stand, the defendant turned to his attorney and, according to 3 separate observers in this courtroom, including my own bailiff, checked the time on his watch. Not requested by me to be noted, but I noted it anyway because it told me something. It told me that even sitting 4 feet away from the woman he nearly ran down, this was still, in his mind, an inconvenience to be waited out. I have been on this bench 43 years. I have watched teenagers make genuinely foolish human mistakes, kids who knew instantly they'd done wrong and showed it with tears, with apology, with real shame. I have watched people from the hardest circumstances imaginable sit in that chair with their heads in their hands, truly undone by what they'd done. And in many of those cases, I have shown real mercy. I have reduced sentences. I have offered community service instead of incarceration. I have looked someone in the eye and told them I believed they could do better because I did believe it. I believe in redemption. I believe people change. But I believe just as firmly in accountability. Actions carry consequences. And when someone demonstrates a consistent, deliberate, unrepentant pattern of disregard for the safety of others and the rule of law, this court does not merely have the option to respond, it has an obligation to protect the community, an obligation to make clear that no one is above the law in this room. Now let me address something else, brought directly to my attention, something I would be failing this community and the very concept of justice if I did not address openly. The defendant's father, Robert Thornton, CEO of Thornton Industries, a company that owns 17 commercial properties in downtown Providence, 12 residential developments across Rhode Island, and employs more than 230 people, has spent the weeks since this arrest working behind the scenes to make this case disappear. Between August 20th and September 5th of this year, my chambers received 7 separate phone calls, 4 written letters. 3 individuals came to my office in person, including a city councilman, an attorney from a prominent Westminster Street firm, and the president of the Providence Chamber of Commerce, all carrying some version of the same message, that perhaps his son had learned his lesson, that perhaps a generous donation to a local foundation would be the appropriate way to resolve things. Figures between $50,000 and $75,000 were mentioned. Let me be crystal clear, and I want everyone in this room and everyone watching to hear it. I do not care how much money a family has. I do not care how many buildings they own, how many people they employ, or how many phone calls they're willing to make. I do not care if the offer is $50,000 or $5 million. Money does not buy justice in this courtroom. Influence does not purchase a pass on consequences. No donation, no backroom conversation, no visit from a city official changes what happens here today. That is not how this works. That is not how it will ever work while I am sitting on this bench. I want to share one more detail from that period because I think it matters. On September 3rd, Robert Thornton himself requested a private meeting in my chambers. I denied that request, as I deny every such request, because private meetings between a judge and the parent of a defendant have no place in this process. Instead, I had my clerk inform him in writing that any communication regarding this case needed to go through the proper legal channels in open court, on the record like everyone else's. I never heard from him directly again. I mention this not to embarrass anyone, but because I think it illustrates something important. The instinct, when you have spent a lifetime accustomed to problems being solved with a phone call, is to assume every problem can be solved the same way. It cannot. Not here. I also want to address something defense attorney Morrison raised in her closing remarks, because I told her at the time I would give it real consideration, and I have. She argued that the court should weigh the chilling effect a custodial sentence might have on a young man's future employability, and she cited his degree, his internship history, and letters of recommendation from two of his former professors at Boston University describing him as bright and capable of growth. I read every one of those letters carefully. I do not doubt that Maxwell Thornton is bright. I do not doubt he is capable of growth. But capability is not the same as demonstrated character, and this court sentence is based on what a person has actually done, not on the resume of who they might someday become. If anything, the letters underscored my concern rather than easing it, because a young man with every advantage this world has to offer, degree, family name, professional network, financial safety net, chose, twice in the span of 3 days, to treat other human beings as obstacles rather than neighbors. That is not a failure of opportunity. That is a failure of character. And character is precisely what a courtroom exists to hold accountable when opportunity alone does not. Because when I think about this case, I don't think about Robert Thornton and his $400 million company. I think about the families of Elmwood. I think about parents who heard a car scream down Cranston Street at 70 miles per hour on an ordinary Thursday afternoon and felt their hearts stop, wondering if their child was outside. I think about 72-year-old Dorothy Henderson and her husband Frank, 74 both retired teachers who spent decades educating the children of this city who were crossing that street on August 15th at 4:33 p.m., 4 minutes before the traffic stop, and had to throw themselves back onto the curb because a $120,000 Range Rover would not slow down for them. I also received a written statement from a neighbor, Mr. Anthony Reyes of 233 Cranston Street, who was standing in his front yard on August 15th when the Range Rover passed. He wrote to this court that he had to grab his 6-year-old daughter by the shoulder and pull her back onto the lawn because she had been standing near the curb waiting for the mail truck. He said in his letter that he has lived on that street for 11 years and has never been more frightened in his own front yard. That letter has been entered into the record as Exhibit H, and I have read it more than once. I think about every young person watching cases like this one and asking the question so many of us ask at some point. Does the justice system actually work the same for everyone, or is it different if you have money? Different if your father makes the right calls, different if your family name opens doors. And I think about what could have happened. We are extraordinarily fortunate that no one was physically hurt in either incident. But sit with the reality for a moment. What if a 7-year-old had been on the sidewalk at 241 Cranston Street when that Range Rover came through at 70 miles per hour? What if Mrs. Henderson had been a second slower? What if a child had chased a ball into the street? These are not dramatic hypotheticals. They are the ordinary texture of life in a residential neighborhood on any given afternoon. The only reason we are not here for something far worse is luck, blind luck, and I refuse to let that luck become a reason to treat this case as anything less than what it is. I have grandchildren, and when I picture any one of them playing outside on a warm afternoon on a street that looks exactly like Cranston Street, and I think about someone driving 70 miles per hour through it with the contempt for human life documented in this case, something runs through me that I can only call primal fear. It reminds me, on a level deeper than statute or precedent, that this was never really a traffic case. It is about whether the people of this city can feel safe in front of their own homes. Now, the recommendations before me. Assistant District Attorney Sarah Chen, 9 years with the Providence District Attorney's Office and over 300 traffic cases handled, is asking for a $10,000 fine, a 2-year license suspension, 150 hours of community service, and 90 days in custody. Defense attorney Jennifer Morrison, and I'll say plainly, she is a capable advocate who has done everything she could for her client, is asking for leniency. A $3,000 fine, 80 hours of community service, pointing to her client's clean record, his degree from Boston University in 2023, and the damage a harsh sentence could do to his future. I have listened to every word from both sides. I have reread the police reports. I have watched the Ring doorbell footage from August 18th. I have read the Instagram posts. I have thought about his age, his background, his future. I have tried to give every argument its proper weight, but I keep returning to something fundamental. We have laws, speed limits, and consequences for a very specific reason: to protect people. Not to punish for its own sake, to protect. What troubles me most about this case is not the speeding, serious as it was. It is not even the reckless endangerment, though that alone would warrant real consequences. It is the attitude, it is the arrogance, it is the total, stunning absence of any recognition that his actions endangered real people, real children, real families, real lives. Looking at the totality of the evidence, the police report, the social media posts, the doorbell footage, I see someone conditioned over 23 years to believe consequences are for other people, that the law applies to everyone except him, that the name Thornton and the wealth behind it will always be there to make problems vanish. Not today, not in this courtroom, not while I'm sitting in this chair. Let me speak briefly to the philosophy behind sentencing, because I think it matters that people understand why judges decide what they decide. We are not trying to be cruel. We are not trying to ruin a life or satisfy some institutional appetite for punishment. We are trying to accomplish several things at once: punish the specific wrongdoing, deter the individual from repeating it, send a message to the community that this conduct will not be tolerated, and take concrete steps to protect the public from further harm. In most cases, I can balance those goals with a sentence that is firm but carries real mercy. But here we have violations on 2 separate dates: a documented, total absence of remorse, attempted intimidation of a law enforcement officer, deliberate public mockery of that officer in front of nearly 50,000 people, and a repeat offense just 72 hours after the first citation. 72 hours. That is how long the message of that first stop lasted. This tells me one of 2 things. Either this defendant genuinely does not grasp the severity of what he did, in which case this court needs to make it real for him, or he understands perfectly well and simply does not care, in which case this court needs to make it real for him. Either way, the conclusion is the same. Anything less than a substantial consequence would be a failure of this court's basic duty to the people of Providence. There will be people who say I am being too harsh, that I am known for toughness balanced with humanity. So why so severe here? My answer is this: compassion without accountability is not compassion. It is something else. It is enabling. When I give someone a break, it's because I see genuine remorse, a person who understands what they did and carries the weight of it. I do not see that here. I see someone upset that he got caught. I see someone who still believes this should have been handled quietly, with a few phone calls and a generous check. Let me address the clean record directly. Yes, it's true, Maxwell Thornton has never been arrested or convicted before. I've considered that. But most 2 3-year-olds have no criminal record. That is not an achievement. It is the baseline expectation of citizenship. We do not discount a sentence because someone managed to avoid breaking the law until this particular moment. The absence of a prior record does not outweigh a repeat offense within 3 days, the attempted intimidation of a police officer, and a social media campaign built to humiliate him. And on the matter of youth, yes, 23 is young. But at 23, you are old enough to vote, old enough to serve in the military, and carry a weapon in defense of this country, old enough to sign binding contracts, old enough to know that 70 miles per hour in a 25 zone can kill someone, old enough to know that threatening an officer is a crime, not leverage, old enough to know that mocking someone in front of 50,000 followers is a choice with consequences, and certainly old enough to understand that repeating the exact same dangerous behavior 3 days after a citation is not a mistake. It is a decision. So here is what I have decided. I want to be clear that I have weighed this carefully from every angle I know how to weigh it. On the reckless driving charge from August 15th, citation 24 to 8,847, the maximum penalty under Rhode Island general law, 90 days in the adult correctional institutions. On the charge of attempting to intimidate a law enforcement officer, an additional 60 days consecutive. On the reckless driving charge from the second incident, August 18th, an additional 90 days, also consecutive. Total, 240 days, 8 months, served at the men's division of the adult correctional institutions on Howard Avenue in Cranston. No early release for good behavior, no work release, no special accommodations. You will serve your time exactly as every other person in that facility serves theirs. Reporting date, December 2nd, 2024, 9 a.m. In addition, a fine of $15,000 due in full within 60 days by January 26, 2025, split 3 ways. $5,000 to the Rhode Island Victims of Reckless Driving Fund, $5,000 to the Providence Public Schools Safe Streets Education Program, and $5,000 to the Providence Police Department's Community Outreach and Training Programs. Something real and lasting will come out of this case. Your driver's license is suspended for 3 full years, effective today, November 27th, 2024, through November 27th, 2027. When that period ends, you will retake both the written and road tests. You will complete a minimum 30-hour driver's safety course, and you will perform 200 hours of community service, specifically with Mothers Against Drunk Driving's Rhode Island chapter, or with families of traffic accident victims at Rhode Island Hospital's Trauma Center, so you can sit with real human beings and understand, in a way no courtroom can convey, the actual cost of driving the way you drove on August 15th and August 18th. You are prohibited from operating any motor vehicle during the entire suspension. If you are caught behind the wheel, you face additional criminal charges and a minimum of 1 additional year in custody. No exceptions, none. I want to explain my reasoning plainly because I believe you're owed transparency. 8 months is a real sentence. It is not a headline. It is not theater. It is a genuine consequence for genuine conduct that endangered real people. But it is not a life sentence either. You'll be out by August of 2025, still 24 years old, with your whole adult life ahead of you. You needed this lesson now before your arrogance and your certainty that you were untouchable led somewhere that could never be undone, because that is exactly where this was heading. I would rather you spend 8 months angry at me than spend the rest of your life knowing you killed someone because you believed the law didn't apply to you. Some will say I made an example of him because of who his father is. They're partly right, I am making an example, but not because of who his father is, because of who he chose to be on August 15th and August 18th. If this had been a first offense, if there had been one moment of genuine remorse at that car window, if he had not gone out and repeated the exact same behavior 3 days later, we would not be here like this. I would have fined him, assigned community service, suspended his license, and sent him home with a serious warning. That is not what happened. To every parent watching, teach your children that every person they encounter deserves respect. Teach them that officers like Daniel Martinez are human beings doing a hard job. Teach them that laws exist because without them, none of us are safe. Teach them that money and status do not measure human worth and do not exempt anyone from accountability. Because if you let a child grow into adulthood, believing your influence will always shield them from consequence, you are not protecting them. You are setting them up for a fall. And when that fall comes in a room exactly like this one, it will be too late. To Maxwell Robert Thornton, you are 23 years old and you have a long life ahead of you. This sentence is not cruelty. It is not about your father, his company, or his phone calls. It is about what you did and what you chose to do again 3 days later. 8 months from now, you can walk out and make a choice. You can be bitter, or you can choose to understand you were wrong, to become someone who sees other people as human beings, whose safety matters as much as your own. I hope you make that second choice. But that hope does not change what I've decided today, because accountability comes first. It has to. To Officer Daniel Martinez, badge number 347, 18 years of service, here in this courtroom today. This court sees you. This community sees you. What happened to you on Cranston Street was wrong. The way you were mocked online in front of tens of thousands of strangers was wrong. And the professionalism and integrity you showed through every moment of it is exactly what we should expect from everyone who wears a badge in this city. Thank you. One last thing, and then I'll let the bailiff do his job. 43 years ago, when I was sworn in, an old judge I clerked for told me something I have never forgotten. He said, "The law is easy, judgment is hard." Anyone can read a statute. What you're being asked to do is decide every single day what kind of city you want to live in. I have thought about those words more times than I can count, in cases far less public than this one, and in cases far more devastating than this one. I am thinking about them again right now. The city I want to live in is one where a 72-year-old retired teacher can walk to the pharmacy without fearing for her life. It is one where a police officer with 18 years of honorable service can do his job without being filmed, mocked, and turned into content for someone else's entertainment. It is one where a young man with every possible advantage learns, before it is too late, that those advantages are not a shield, they are a responsibility. That is the city this sentence is trying to build, one case at a time. The same way it has been built one case at a time for the last 43 years, I have sat in this chair. This court is adjourned. The defendant, Maxwell Robert Thornton, will be remanded into custody immediately. Reporting date, December 2nd, 2024, 9 a.m. The $15,000 fine is due by January 26th, 2025. The license suspension is effective immediately, running through November 27th, 2027. Bailiff, please proceed. As the bailiff stepped forward, Maxwell Thornton's expression shifted for the first time all morning. The smirk that had been fixed on his face since the proceedings began finally faded. His mother, seated in the second row, put her hand over her mouth. Robert Thornton, who had not said a single word throughout the entire hearing, simply lowered his head. Officer Martinez remained in his seat until the courtroom had mostly emptied. A reporter who approached him afterward asked if he felt vindicated. He said only that he hoped the young man would use the 8 months to become a better person, and that he did not take any satisfaction in what had happened, only relief that this time the law had been applied the same way it would be applied to anyone else who walked through those doors. Outside the courthouse, a small crowd of Elmwood residents, including Mr. Reyes and his daughter, waited in the late November cold. When the news of the sentence reached them, there was no cheering, no celebration, just a quiet, collective exhale, the kind that comes when people who have felt unheard for a long time finally feel like someone was listening.